Hello everyone. So this is Rayush from Team Lawspot. Thank you for joining us today for this webinar. So as we all know that last year our parliament has introduced a pretty major amendment to the Arbitration and Conciliation Act. The said amendment basically seeks to make India a little more arbitration friendly than it is presently. So yeah, in today's discussion, we'll be discussing the impact of this particular amendment to the entire arbitration landscape of India. So our speaker will discuss this particular topic for somewhere around 20 to 30 minutes. And then we'll have uh, a Q&A session of 10 to 20 minutes where you can ask questions and our speaker would be more than happy to answer those questions. Meanwhile, during the course of this entire webinar, you can post in your questions into the chat box that is available on your screen. So without further ado, I would like to introduce the speaker for this webinar to all of you. So the speaker for this webinar is Mr. Surjendu Das. And Surjendu sir has completed his law from NUJS Kolkata back in the year 2008. After that, he joined one of India's most famous law firms, Amarchand and Mangaldas, as it was known back then. And for working there for somewhere around 11 to 12 years, recently in the last year, he started his independent practice in Delhi. So he's an advocate on record before the Supreme Court of India, and he handles litigations for a lot of companies as well as private parties before Supreme Court, various high courts, and other judicial forums across India. So over to you, sir. Let's begin this discussion.
Thank you, Ayush, for introduction. And I will straight away go for the topic. It's very specific topic, 2019 Arbitration Amendment Act. So I have prepared a short presentation as well. I think it will be better if I share with all of you so that we can skim through one by one the important amendments. So yes, topic is how 2019 amendment has impacted arbitration regime in India. Now 2019 amendment is not a stand-alone amendment. It's premised on 2015 amendment that we should keep in mind, because after many years, after 1996 amendment, 1996 Arbitration Act, there was a necessity which was felt to change the arbitration sort of structure, how it is handled, and how things are taken care in arbitration to sort of minimize the court's intervention and expedite the process, more importantly. So that was 2015 amendment. So one of the most criticized and important amendment was fixing the time frame for arbitration to render the award, and court's jurisdiction in terms of international commercial arbitration. It was completely made seat-centric, and so on and so forth. There are so many other important amendments which happened in 2015. Now, the reason of giving this background is that now arbitration is so much of attention today. Like everyone's speaking about small changes, court orders, some interpretation, some contradiction. It's catching the eye of international community how India is sort of evolving with arbitration. And it has led to several new jurisprudence, for example, Schedule 5, Schedule 7, which were introduced in 2015 amendment. So these are all new introduction to arbitration of 1996. And we have been discussing this since last 5-6 years, that there will be changes, there have been changes, and courts are interpreting different way. Sometimes court is pro arbitration, sometimes we feel that no, it's not the right way to interpret. So keeping all this in mind, I think we should now gradually look towards how the arbitration diagram has changed over the period of time. So as I said that after 1996 Arbitration Act, we had 2015, which is derived from 246 Law Commission report. There are several recommendations given. So most of them have been accepted, few not accepted. So it was criticized. So you had 2015 amendment, and there it was found that there are other loopholes as well. And the necessity for institutionalization of arbitration was not met in 2015 amendment. That called for constitution of high level committee, empowered committee, whatever. It's Justice Sri Krishna committee report, on the basis of which we had 2018 amendment bill. So what you are reading as 2019 amendment, it was original 2018 amendment. It was placed before the parliament. I think one of the houses had already passed the bill, but April it was the Lok Sabha was dissolved. So this amendment bill of 2018 could not be implemented. Now 2019 amendment bill had certain couple of tweaks, and then it was introduced before the parliament. And I have the legislative history here. You can look at it. It says that it was 15 July when it was passed by upper house. Lower house passed on 1st August, and presidential assent happened on 9th August. Now, having said so, it was notified on 30th of August 2019, except provisions relating to section 11, which is appointment of arbitrator, and your Arbitration Council of India. All those provisions have not been notified yet. Now, if you look at the objective of this 2019 amendment, is to strengthen the institutional arbitration and minimize the court intervention. Of course it is. That has been the endeavor of 2015 amendment, but I think there was something more to do. So that has been filled in by 2019 amendment. So if I can broadly categorize, I would say there are two parts to 2019 amendment. First being that there were certain obvious errors like ambiguities as well, which had to be cleared. So that purpose is served by 2019 amendment. And the second objective was promoting institutional arbitration, which has been done by way of 2019 Amendment Act. Now, this too can be further expanded by three different heads under each portions. For correction purpose, I would say that in relaxation of timeline, which I'll deal with in detail, section 29A. This confidentiality and immunity, which have been inserted by 2019 amendment, and applicability of Amendment Act of 2015, which is a result of section 26 of 2015 amendment. These are the major corrections, or I would say that they try to do something with it in relation to 2015 amendment. So far as the institutionalization is concerned, now we have Arbitration Council of India. We have, in the sense, it has been inserted in the Act. Appointment of arbitrators and qualification of arbitrators, these have been falling under the institutional arbitrations. We'll briefly touch upon these aspects as well. Now, as I said, the first and foremost important aspect of timeline is section 29A, which was introduced in 2015 amendment. Now, what is 29A? We have been discussing, and what happened after 2015 amendment. There were the critics were criticizing that it's very unrealistic, unreasonable timeline to have. How can we complete within 12 months? This is because the practice for what everyone had is that to drag it for years and years, to several years, maybe 5-7 years. So all of a sudden you are saying, no, you have to complete arbitration within 12 months. That's, of course, is unreasonable, not fair. But this had to be achieved. This sort of to promote India's arbitration hub. The expeditiousness was necessary. So I think this was a thing. Sorry. Yeah. So I think this was a good point that we had. Just a minute. Yeah. Now 29A of Arbitration Act said that, I'm talking about 2015 amendment. Sorry. It said that arbitration award has to be rendered within 12 months from the date of entering upon the reference. Now, you should keep in mind that when you say that you have to complete the arbitration within 12 months, how it is starting? It's starting from the date of entering reference, which is different than commencement of arbitration, because many people confuse between commencement and completion, for the purpose of 29A. Arbitration commences from the time when you have invoked arbitration. Keep in mind, under section 21, you have invoked arbitration, which has been received by, the notice has been received by the other side. So arbitration is deemed to have been commenced. That is different than how your 12 months calculation will start. Your calculation will start, the 12 months will start from date of entering into reference by the arbitrary tribunal, which is by the constitution of the arbitrary tribunal. Generally, it is said that when the arbitrator or arbitrators, in case of 3 arbitrator panel, they receive the notice of appointment, that time the time limit has started. Now, I hope you understand the difference, because what happens is that you may have invoked arbitration. It happened with me as well, because we had invoked arbitration in 2017. Now, for 1 year, nothing happened. Nothing happened. The arbitration tribunal was considered in 2018. So by that time, you can't say that 12 months is already over, because your arbitration tribunal was considered in 2018. So your time frame is starting from 2018 for 12 months. Now, by mutual consent, parties can extend for another 6 months. So there we have total 18 months. And beyond that, you have to apply to the court seeking further extension beyond 18 months. There, the court has power to impose cost on parties if it is because of the default of party. They have taken an undue adjournment to delay the arbitration. They can also impose, court can also impose cost on the arbitrator if it finds that the arbitrator has delayed, he didn't have the properly managed arbitration. Because of him, the arbitration was delayed. He can reduce his fee. The cost is not some monetary amount, but his fee will be reduced. So that was a 2015-29 section 29A amendment. Now what happened is that it was criticized because of the reason that it said in international commercial arbitration is slightly different ballgame, because you have multiple volumes of papers, documents, so you can't finish it. So give some relaxation, this and that. So keeping all this criticism in mind, and of course, Justice Sri Krishna Committee report, what was changed by 2019 amendment is that you get additional 6 months time frame for what to complete the pleadings, because it is understood in arbitration completion of pleading takes the substantial time. So it has to be made in time-bound manner in 6 months. So your 12 months will start after completion of 6 months, which is the time frame for pleadings. That's how 23.4 was amended, or there's an insertion happened. That's 23.4. Now what happened now? Consequently 29A also had to be amended. It said that this 12 months period will start from after completion of pleadings of 6 months. So now you have 6 months for pleading, 12 months for rendering the arbitral award, and parties can mutually extend for another 6 months. So you have, by consent or what the legislative intent is, you can finish the arbitration within 2 years. Beyond which, again, you have to approach court to seek further extension. Now, this 2019 amendment says that this 12 months period of arbitration will be applicable in all matters other than ICA, International Commercial Arbitration. So international commercial arbitration has been exempted from this 12 months time frame, but it has been also said that tribunal should endeavor to finish within 12 months, keeping in objective that a legislature, our statute says that it should be in a time-bound manner. So that's not directory, but it is a sort of you have to keep that in mind. Now the question comes: it is that the international commercial arbitration is exempted, but keep in mind not the institutional arbitration. So if it happens that you are choosing ICC arbitration for a domestic arbitration, so there, though your ICC rules are saying something that there will be some time frame to follow the steps, but you're bound by Arbitration Act of 1996, which is amended in 2019, right? Now, another important aspect is that what happens if the arbitral tribunal cannot finish within 12 months, or as it is extended by another 6 months. Then the natural corollary is that the mandate of the arbitrator shall stand terminated. Now, what happens that before the expiry of 12 plus 6 months, 18 months, the party has applied for extension. Now, this provision was inserted in 29A to say that the mandate of the tribunal will continue till such time the application for extension is decided. This is to safeguard the interest of the arbitration. But the question is that if after expiry of 12 months or plus 6 months, if someone applies for extension, whether the arbitral tribunal mandate shall stand or it will be terminated or not is the question. Though this one of the High Court has set aside an arbitral award on the ground that it was passed beyond 12 months. It was not a valid arbitration award, but this is debatable because keeping the objective in mind and other things, whether such relaxation should be granted. But strictly speaking, such relaxation should not be granted because it's a mandatory provision. And there's another provision added in 29A to say that arbitrator to be given opportunity to be heard before the fee is reduced. Generally, it's not saying that the arbitrator's fee is reduced by the court, but if it happens, then of course court should ask him why the delay happened in arbitration, so that he has the reasonable opportunity to understand, where the exact wrong, like how it was delayed. So this was section 29A. Now, another important aspect before I get into, what's the time? Already 5:50. This 29 is so interesting. We can keep on discussing. Maybe we'll discuss offline sometime. I'll get into now confidentiality aspect. See, confidentiality aspect is very important. Now, in Indian arbitration, the confidentiality was predominantly governed by the parties' agreement. There was no statutory provision. What happened in 2019 amendment has given a statutory recognition to say that whatever happens in arbitration, arbitrator, arbitral tribunal, and parties shall maintain the confidentiality, because confidentiality is one of the cornerstone of arbitration. The arbitration jurisprudence is based on the confidentiality aspect. Now, there is some exception. For example, you have to enforce the arbitral award or implement it somehow, then of course you need to disclose it. So except that limited purpose, whatever happens in arbitration, including the arbitral award, everything is very confidential. And for that purpose, so you cannot cite your arbitral award as a precedent in Indian scenario. Because it's confidential in nature, it cannot be cited, even if the parties want. There's another provision, 42B, which is regarding protection of arbitrator for actions done in good faith. Because there's a trend in Indian litigation, I would say, that to implead arbitrator as a party to arbitration challenge, for example, section 34, some ground has been pleaded that there's a misconduct by the arbitral tribunal. And just to sort of justify why there's a misconduct, the petitioner impledes the arbitrator as a party. So generally they're sort of entangled in the litigation as well. To safeguard their interest, this provision has been inserted in 2019 amendment. Now, another important aspect is that what I have put in the comment. See, now when you're talking about the disclosure for the purpose of only enforcement, I think it is slightly departure from the committee's recommendation, because it's the way it is now enacted is very narrow. You cannot disclose it anything else but for enforcement. But there is a legal duty to protect or enforce a legal right. Then you also should have a right to disclose the arbitral award. So that recommendation has not been taken into consideration. And also there is a issue regarding Arbitration Council of India. What happens is that if you read the provision, you will see that Arbitration Council of India will be the depository of electronic arbitral award in electronic form. So there's the question comes, if you're already giving it to the Arbitration Council of India, so that may be a breach of the confidentiality, though I hope there'll be safeguards by the Arbitration Council. So those are debatable questions on confidentiality. Next is on applicability. This is the highly debated one. This is derived from section 26 of 2015 Arbitration Amendment Act. So now what section 87 has been inserted to say that whatever changes happened regarding applicability by 2015 amendment shall not apply to arbitration proceedings which commence before the commencement of 2015 Amendment Act, or court proceedings which commence prior to 2015 Amendment Act, which came into effect in October. So any court proceeding or any arbitration proceeding which has commenced after 2015 Amendment Act came into operation, in that case only your 2015 amendments will be applicable and not previous arbitration or court references. Now this was debated. There are multiple judgments by different high courts. It was settled. The issue of section 26 was settled in BCCI versus Kochi. Many of you may know if you have read it. Now BCCI Kochi was concerned about section 36 applicability. Section 36 is regarding the automatic stay. So the issue was that 2015 Amendment Act has been implemented. Now if a section 34, which is for challenging an arbitral award, has been filed before 2015 amendment, whether this 2015 amendment can be applied to that or not, because of reason that the automatic stay provision, which was laid down by NALCO decision, said to be wrong. So it said that in this BCCI judgment, it was said that now see section 36 is sort of a procedural in nature. It will have retrospective operation. So even if section 34 was filed before coming into operation of 2015 amendment, this section 36 amendment section 36 will be applicable. So that was the objective of 2000 amendment. That's how it was. It was laid down in BCCI by the Supreme Court. Now what happened? Thereafter 2019 amendment came, by which section 87 was inserted, and it nullifies what was held by BCCI. So of course Supreme Court had the reason to be aggrieved, and in fact Justice Nariman also had made a point in BCCI to for the consideration of the legislature that you should keep in mind section 87 that was in draft form, that you should not implement in this way because that will defeat the purpose of 2015 amendment. So that was not sort of taken care by the legislature, and because of which this HCC has been HCC judgment in Supreme Court they said that we are striking down 87 because this is against the very purpose of 2015 amendment. It's you cannot nullify the law laid down by us in BCCI. That too without considering the legislative objective and which was based on the Sri Krishna Committee report. So that's in nutshell, that's how Section 87 has been derived. Now, as of now, then Section 87 does not operate, and then we have gone back to BCCI Kochi regime, which is very strict regime in terms of enforcement, I would say. Next slide is on certain other important amendments. What happened in 2019 amendment? First is that, sorry, Section 17. So Section 17 is for interim relief by the arbitral tribunal. So 2015, I think it overlooked that, and it said that parties can approach the arbitral tribunal during and after the arbitral award for any interim relief. So that's not feasible because once the arbitral award is passed, the tribunal becomes functus officio, and then you can't approach the tribunal saying that you should grant me some interim relief. So that was an obvious error which has been rectified here by of amendment. Another very small aspect, but it has practical application. Section 34 had in by of 2015 amendment, it overlooked this thing, that it says that parties have to furnish proof for the purpose of setting aside the arbitral award. So that has been changed to that establishes on the basis of record of the arbitral tribunal. The reason being that once you say that furnishes of proof is again very subjective. If you have to prove something, then you must add with evidence, and all these procedural aspects come applying CPC Evidence Act. So some parties had taken advantage of this furnishes proof and say that we need to give some proof beyond what has happened in arbitration. So that is not the objective. So it was cured by 2019 amendment to say that on the basis of the arbitral record, you have to establish that the award is against public policy, so on and so forth. So that's Section 34 amendment. Another small amendment is Section 45, which is in comparison to Section 8. Section 8 and Section 45 are with regard to power of the judicial authorities to refer the parties to arbitration. Section 8 requires the court and the judicial authority to look at the prima facie about the arbitration agreement's existence, whether it is null and void, inoperative, incapable of being performed. Whereas Section 45 didn't say so. So now it has been added that the view of the judicial authority should be prima facie only. So it's not to be established that the arbitration agreement is in trouble. Now, an important amendment is with regard to Section 11. Section 11 has been amended by 2019 amendment. Now Section 11 has not been given effect to not Section 11, but amendment to Section 11, because of the reason that now this institutionalization of arbitration, which is sort of guided by Arbitration Council of India, has been incorporated in Section 11. So unless that Arbitration Council of India is into operation, you can't operate the changes in Section 11. So it has not been given effect to. But couple of interesting changes I must highlight, that once this Arbitration Council of India comes into picture, is given effect to, then the power of the court to designate or appointing the arbitrator will change. Now, what the court will do is that court will designate the arbitral institutes for appointing the arbitrator. So see that how the power is getting shifted from court to arbitral institutes. Now there is a time frame given, within 30 days from the service of notice of the other side, the Section 11 should be disposed of. So this is very to cut short the time frame, because appointment you should not take long time to get it solved, and then there will be arbitration. So there's a fixed timeline given of 30 days. And there are other things also you can read on slide. I'll just quickly jump because of the paucity of time. But I will highlight one important aspect, because this has been a matter of debate, and we have been advising the client also. What happened? Section 11(6)(a), which was introduced by a 2015 amendment, said that the court's power while appointing the arbitrator will be to see only to see the existence of the arbitration agreement, nothing beyond that. So what if you file an arbitration application before the court, High Court or Supreme Court, the only limited power the court has to see the existence of the arbitration agreement. That's it. It can't decide the other aspects surrounding the arbitration or get into the merits. Only it should be a view of existence. For example, someone is arguing that the arbitration agreement has been procured by fraud and all. So those questions to be referred to the arbitral tribunal, not to be decided by the court. Now, what happened? 2019 amendment has omitted section 11(6)(a). The rationale behind is that since the court is designating the arbitral institutes to appoint, the court doesn't have to look into the existence of the arbitration agreement. That is the rationale, because it is still debated whether once 2019 amendment is given effect to what extent court will have power to look into the arbitration cases under section 11. But irrespective of that, what has been argued is that now what happened, once you have omitted 11(6)(a), 2019 amendment, then whether court automatically has power to look into other aspects beyond the existence of arbitration agreement. So there are two judgments I've cited on the right hand column. You can see it. It says that these are both the Supreme Court judgments. So this was argued that then the power of 2015 amendment again coming into picture, because it has been deleted. So court has wider power while evaluating section 11. So Supreme Court, of course, has rejected this contention. It said that no, that's not the case, because ultimately court can only look into existence, not beyond that. And once you have 2019 amendment with regard to Arbitration Council of India, then also it will only designate the particular institute for the purpose of appointment of arbitrator. So with that, I'll proceed with the there's only one slide left for my talk, and that's the most debatable subject, I would say. This is in relation to Arbitration Council of India. This is on the basis of committee recommendation for establishing an autonomous body to monitor the working of arbitral institutes of India. Now, this has been a matter of great concern, because if you look at the structure of the Arbitration Council of India, it appears that prima facie, it has I'll not say interference, but involvement of government bodies, government people, and that will I'll say to some extent will curb the rights of different institutes to operate, because that's not the purpose. Because once you have chosen arbitration, which is completely a private setup, but I think government have seen much importance in arbitration in terms of revenue or whatever you say. So then government, I think they wanted to have some sort of control by different ministry or bureaucrats to control the Arbitration Council of India, which will designate, accredit different arbitral institutes. That raises a question, because arbitral institutions are saying that why will a body will differently accredit ourselves, than what we are. We are already present in international arbitration, area. People know us. People recognize us, then I don't need separate accreditation from ACI. So this has been a matter of debate, but that's how it is. And if you look at the power of the Arbitration Council of India, it has different powers in terms of grading also, as I said, that on the basis of the infrastructure quality. For example, if you consider ICC or SIAC, they can't operate. See, they have presence in India, but they don't have an infrastructure that way. So if you're trying to grade them, in terms of infrastructure, the quality and calibers are different thing. But there's no infrastructure in place. So how do you grade them? So this has been a matter of debate. But once it is implemented and there are further debates raised or some challenge happens, whatever, then we'll see how it is to be implemented. Now, another important aspect is that we have a new schedule called 8th schedule, which is giving description which are mandatory in nature to qualify who will be the arbitrator. And I have the problem in the first qualification itself. In fact, I have in front of me Schedule 8. The first point is that the qualification criteria says that a person shall not be qualified to be an arbitrator unless he's an advocate within the meaning of Advocates Act, and importantly, having 10 years of experience as an advocate. So this has been a debate as well, that when we are trying to broaden our horizon in arbitration, we have to attract international arbitration community, international arbitrators to come in India and do arbitration. And of course, they are not advocates under Advocates Act. So how you square it up? So there has been a debate on this point. So we'll see how this gradation and accreditations are taken care of. But as of now, we have sort of a qualification, and mostly are saying that 10 years of minimum experience. As a CA also, as CS also, you should have minimum 10 years of experience to be qualified as an arbitrator under 8th schedule. So with that, I will complete my talk on presentation on the topic. And if any one of you have any question, I'd be happy to respond.
Sure, sir. So it was a pretty informative session from your end. So let's move on to the Q&A session for today. So the first question that we have received from one of our participants is that what happens in case if the pleadings are not completed within the period of 6 months as stipulated under the Act? And so in that case, will the period of 12 months will commence after that period of the initial period of 6 months has expired, or whether it will, I mean, the concerned authorities, the court would count the period of 12 months from the date on which the completion of pleadings was supposed to take place?
Yeah, it's very interesting question, and this has been a matter of debate as well, because of the reason that the new provision is silent on this aspect. Because what happens if you can't complete the pleadings within 6 months, whether your right to complete pleadings is taken away by the tribunal, or it can be extended beyond 6 months, but within the time frame of another 12 months, is a debatable question. There is no answer to it. There's another problem, practical problem, I would say. See, what happens, you complete your pleadings within 6 months, but you want to amend some pleadings after 6 months, then how do you count it? So these are practical difficulties, and we will see how to counter those as and when we are executing those, because it's not yet has been faced by any of the arbitration, but hopefully very soon we'll have this kind of queries.
Fair enough, sir. Fair enough. So there are another couple of questions that we received on our email. We'll quickly try and wrap it up. So the first one is that there has been a recent development in the arbitration regime of India where a lot of high stake arbitrations, arbitrators from outside India, for example, Queen's Counsel, are appointed to adjudicate disputes. How do you perceive this particular change in the Indian arbitration regime?
So I think on my last point, that's what I said, that is very difficult to adjust with 2019 amendment objective, because when you are giving some qualification of the arbitrator who has to be qualified as an advocate under Indian Advocates Act, and of course you can't expect a QC to be an advocate uh, under Indian Advocates Act. So it is going to create some problem. But hopefully we'll have some solution by way of some clarification or some court interpretation, something like that. Let's see.
Fair enough, sir. So the next question is, it's a very subjective question. So it says that, in your opinion, do you think that the 2019 amendment actually serves the purpose of making India more arbitration friendly as a jurisdiction? Does the 2019 amendment make India a little more arbitration friendly?
I think so, barring a few practical problems what we have been discussing over this talk as well. I think if you look at the objective perspective, of course it's a good one only, because we want to make India as an arbitration hub, and we're trying our level best towards that. We are promoting institution of arbitration, but we have to cure these small defects, because this will be practical difficulty when you're trying to promote your nation as an arbitration hub, because international community will criticize, because once, for example, this one only, if some QC has to act as an arbitrator under Indian Arbitration Act and he's not qualified, that raises question. So you will have to give some clarification on these points, then only it makes sense. So I can see another question. What about the applicability of 2019 Amendment Act insertion of Section 23(4) will applicable on which cases? This has been again a matter of debate. There's a recent Delhi High Court decision which holds that Section 23(4), the amendment by of 2019 amendment, will be only prospective in nature, not retrospective. So an arbitration which has been invoked before 30th August 2019, then you can't apply this 2019 amendment, that is Section 23(4), the 6 months time frame. But there has been a difference in opinion by another judge as well on this point. If I'm not wrong, this issue is also pending before Gujarat High Court, and which will come before Justice Rohinton Nariman soon. It was already pending, but Supreme Court told the Gujarat High Court to decide on this point. My view is that, since Section 23(4) is procedural in nature, so if you go by settled principle, the procedural law always should be applicable retrospectively. So according to that, any arbitration which is even continuing before 30th August, this change should be applicable. But there is another problem to it, because 23(4), though you say it's a procedural nature, but it gives a substantial right as well. Because you see, if you can't finish the arbitration, then your arbitration is getting terminated. So I think that has a flavor of substantial law as well. So keeping that perspective in mind, it can be also argued that it applies only prospectively. So any arbitration which is invoked before 30th August 2019, this change should not be applied. So we have to again see, wait and watch how the Apex Court is deciding, though we have some observations from High Courts already.
Great, sir. So the last question that we'll take, so it says that Section 11, the amended Section 11 has been notified by the government. However, Section 43I has not been notified yet. Section 11(3)(a) states that High Court and Supreme Court shall designate arbitral institutions graded by the Arbitration Council of India. However, if Section 43I has not been notified yet, then how will the courts proceed with appointment of arbitrators in the absence of Arbitration Council of India? The
So
present.
section 3, yeah, so see, what I understand that the confusion is regarding applicability of this change. Now, see, section 3 of the Amendment Act, which deals with changes in section 11, has also not been notified because of the obvious reason that Arbitration Council of India has not been implemented yet. So 43 I is not yet notified, as well as section 11. Section 11 is changes to section 11. So once Arbitration Council of India is set up, then only we'll see the application of designating the institutes by the court under section 11 applying 43I.
Okay, so that's it. I guess those are all the questions for today's session. And it was really wonderful to have you with us. It was a really informative session for all of us. I hope our participants also learned a lot of new things about the latest amendment. And so in case if anybody of you have any queries, if you want to ask anything to Sir, you can write us at info@lawspot.com. We would be more than happy to forward those queries to Sir. And I believe Sir would be also very happy to answer those queries. So thank you.
Sure. It's always a matter of privilege to discuss the amendments changes. Thank you so much.
Sure.
Thank you for
Thank you,
organizing
sir.
this.
Thank you, everybody.